So I am next in the cattle call, and I have been asked during my 4 minutes to talk about what's going on at the Supreme Court in terms of criminal law. And as usual, it is a mixed bag. So in the last few years, the court has decided a number of very significant cases in this area. Some of them got a lot of attention, for instance, like the Trump versus United States, the presidential immunities case. Others did not. Some of them went in favor of defendants. So for instance, in Glossop versus Oklahoma, the court overturned a murder conviction and death sentence because the prosecutor knowingly failed to correct false testimony by a key witness and failed to turn over information about that witness to the defense team. In Thompson versus United States, the court ruled that a federal statute that prohibits false statements doesn't cover statements that are misleading but not false. In Fisher versus United States, another controversial case, the court narrowed the scope of the federal obstruction of justice statute. This was the statute that was used in the January 6th prosecutions, finding that it only applied to witness tampering and evidence destruction, not to non-evidentiary acts such as entering the Capitol without permission. In McElrath versus Georgia, the court unanimously held that a jury's finding of not guilty by reason of insanity was a final verdict for purposes of double jeopardy, precluding a retrial. In Lang versus California, the court held the police officers may not pursue a fleeing suspect whom they believe committed a misdemeanor into a home without a search warrant absent other exigent circumstances. And in Concepcion versus United States, the court held that a district court can consider intervening legal and factual developments when deciding whether to impose a reduced sentence under the First Step Act. In some of these cases, the defendants lost. For example, in Pulsifer versus United States, the court ruled that federal defendants had to meet all 3 statutory conditions in order to receive sentencing relief from a mandatory minimum penalty under the sentencing guidelines safety valve provision. In Jones versus Mississippi, the court upheld the constitutionality of sentencing juveniles to life without parole, so long as the sentencing judge considered the offender's youth and other mitigating factors before imposing a sentence. The court already has several significant criminal cases on its docket for the upcoming term. We haven't even had the long conference yet. So in Villarreal versus Texas, the court is going to decide whether preventing a defendant and his attorney from talking about the defendant's testimony during an overnight recess violates the defendant's Sixth Amendment rights to counsel. In Case versus Montana, the court is going to decide whether a law enforcement officer can enter a home without a search warrant based on something less than probable cause if he believes that an emergency is occurring. And in Rutherford versus United States, the court is going to decide whether district court judges can consider sentencing disparities by non-retroactive changes to the sentencing guidelines or non-retroactive changes from the First Step Act in deciding whether to grant a defendant's motion for compassionate release and a sentence reduction. The justices are a very interesting mix when it comes to criminal cases. You have someone like Justice Clarence Thomas, who is a staunch originalist, who would be probably the most prepared justice to roll back some of the rulings and excesses, in my opinion, from the Warren and Berger courts. He is most often joined by Justice Alito. You have Justice Neil Gorsuch, who is a strong proponent of individual liberties and has sort of taken up the mantle left by Justice Scalia's passing. He often sides with the liberal justices in criminal cases. You have Justice Sonia Sotomayor, who rarely sides against defendants in criminal cases. And then you have the newest member of the court, Justice Ketanji Brown Jackson, who is a former federal defender, which adds a new and interesting perspective to the court's deliberations. So as usual, this should be a very, very interesting term, but then again, they all are. Thank you.